Dr. Sanjay. I am the host of this webinar today, and I welcome you all to this webinar, which is focused on legal metrology rules application in medical device sector. And to me, this appears a very balanced webinar today, as we have a few speakers who are very relevantly connected to legal metrology and medical device segment. We also have voice of industry. We also have a lot of attendees coming in from various industries who have lots of questions. Typically, question answer session starts once we start delivering the webinar. But here I can see that many people are asking questions already. So there is an excitement to understand all about legal metrology in medical device segment. In medical device rules, there is always a requirement for labeling of medical devices, which is pretty extensive. And there are a lot of such requirements in legal metrology rules also. If I don't become very specific to it, I can say that whether it is MDR labeling rules or it is legal metrology rules which require to be put on commodities, the basic questions hover around what, how, where, and by whom, and it is for whom. These are the 5 elements which are generally there. So it starts with manufacturer, seller, who can be a wholesaler, a retailer, or a healthcare setup. Sometimes wholesale institutions also work like a retailer when it comes to high-end medical devices, where they sell individual devices to healthcare units. I have had this problem of legal metrology 10 years back in case of my mother. It would be an eye-opener for me also to learn from experts here. And on the speaker side, we have very, very strong opinion makers and also who have got knowledge. We have Mr. Rajiv Nath, who very actively talks about cause of the industry into all domains, whether it is medical device regulation, consumer affairs, or exports, imports. With him, we will learn a lot because he has got this information directly from industry. Welcome you, sir, in this webinar. And then we have Mr. Devendra Kumar Shakya from Department of Consumer Affairs, Ministry of Consumer Affairs. He would also be joined by Mr. Ashutosh Agrawal little later, who is Deputy Director at the same department. Then we have Dr. Asim Sahu from Central Drugs Control Office, CDSCO. And I know sir personally for a long, long time. And let us also hear him from the medical device rules perspective. Then we have Ms. Simi, who's a policy analyst and Consumer Unity and Trust Society. We would be very happy to take all the questions. And I would say that if you hear some of the answers to your question, let us not repeat those questions when it comes to, so that we can have more hearing from the experts. So let me begin inviting Mr. Rajiv Nath. And Rajiv sir, please enlighten the webinar attendees with this particular subject. Thank you.
Namaskar, everyone. Is my screen visible to everybody?
Yes.
Yes, Rajivji. Rajivji, we'll just quickly check with the audience. Is the voice not clear? Is it clear? Clear,
yes,
audible? Fair enough. Thank you.
A lot of people are saying clear and audible.
Yeah, thank you. Rajivji, please.
Okay, everybody, welcome to this webinar today, where we are going to be educating you all. Of course, all medical devices are coming under regulations this year under the Drugs and Cosmetics Act, and they've already been under the regulations of the Legal Metrology Act, but some people think that they were not so. So to remove any clarification or any doubts, be assured that medical devices are consumer products, and as law-abiding citizens and manufacturers, we do need to take care to ensure that we are, as responsible manufacturers, complying with the laws of the land and the rules of the land. Excuse me. So this presentation is basically going to give you a quick checklist about the various impacts of various regulations have on you. There are 3 regulations which manufacturers need to consider in terms of patient safety and consumer protection. One is the Legal Metrology Act, which comes in the Department of Consumer Affairs. And under this are the packaging commodity rules, which govern your products, especially the products which are going to be sold on retail sale. The second is the Drugs and Cosmetics Act, where for patient safety issues and for traceability issues and for post-market surveillance, you need to comply with the requirements which are given in the medical device rules. And third is the Bureau of Indian Standards Act, whereby certain medical devices or certain products from time to time can be coming under the purview of mandatory ISI marking. Like in the past, thermometers and certain medical instruments were covered. And then in that case, the government passes a quality control order. So again, what is defined in the standard over there becomes the labeling requirement, which becomes mandatory, and the logos and everything becomes mandatory over there. So whether you have to carry the ISI mark with a bottle of water or a thermometer, that has to be seen over there. So that is defined in the scheme of marking, which ISI defines under that over there. But today's focus, and we've got speakers over here for you, which will be focusing only on the first two acts over here. So now this is typically what we've done over here is create a checklist whereby you can use this checklist for the unit pack of sale. What is unit pack of sale? It can be a single piece. It can be a package of 10 pieces. It is the pack at which not less than that pack size will be sold to a consumer. That becomes unit of sale. So if you buy an insulin syringes, which have got 10 syringes packed inside, the unit of sale is not one single syringe in that case, it is a pack of 10 syringes. So on that unit of sale, these are the labeling requirements. So we have to put the name of the device, whether it is a syringe or the thermometer, the details for the user to identify the device and its usage. The brand name is part of this, and the complete description is part of this. So the name of the manufacturer and address of the manufacturing premises or the site, this is also important. And this is something which is required both in the legal metrology as well as in the medical device rules. Then statement about the quantity. 1 unit, 100 unit. If it's a shelf box, 100 unit. If you are making, for example, one pack of 100 pieces or one pack of 10 syringes as the unit of sale, then it should be stating that this is the minimum unit of sale, having this net quantity inside. It can be in grams, it can be in pieces. Date of manufacturing by month and year, the date of expiry, month and year. Now, many countries may be not asking for date of manufacturing. But in India, we are asking for date of manufacturing because sometimes you're having a very limited shelf life and many buyers would like to have the product having at least 2/3 of the shelf life when they buy it, especially an institution buyer. So by the manufacturing date, they come to know how much is the residual shelf life. In case shelf life is very short, they may want to negotiate a discount. The next point is regarding indication whether it contains a medicinal or a biological substance. So if it's a combination product, for example, like for example, a stent, then you need to have the description, whether it is a lot number or a batch number by means of a logo or by means of this prefix over there. Now, if anything is not done in the right manner, you are liable for persecution. So be careful. These labeling requirements are not something which you can wish off. These have to be done very thoroughly, very strictly, very methodically, because an inspector who will pick up your samples from the market will verify against the legal requirements for his particular act on his rule book. And if he finds that it is not complying, then he can persecute you. So whether it is a lot number and not spelled properly, or the batch number of the unit pack and the shelf box or the shipping carton is not matching with each other, it becomes again a question of mislabeling, liable for persecution. So again, special storage conditions, whether you need to have a low temperature or storage in the shade or kept away from wet condition or dry condition, this should be clearly mentioned over there if the quality is going to be impacted. If it's a sterile product, then the word sterile and how it is sterilized. If it is by EO or by gas or somebody trying to claim it is UV sterile, be clear about it. So the regulator will be seeking the validation and verification accordingly. Now, whether it is going to be a physician sample, if you're going to be giving away without an MRP, it should be mentioned clearly over there. Along with that, you need to give a manufacturing license number or the ML number as applicable, or the import license number as applicable. In case the product is going to be not sterile, if it is damaged, there needs to be a statement saying that, or there needs to be a logo stating that. Then the operating instructions of the IFUs, they need to be kept alongside on the unit pack or cross-linked to the, giving a symbol over there that indicates that you have to see the cautionary IFU, which is maybe in the shelf box, or it can be also on the website. So it has to be cross-linked with that. Then the issue about the operating instructions and the maximum retail price. The MRP is something which is not required in the medical device rules. They may now amend that going forward and harmonize that, but it is required in the legal metrology rules, and that has to be inclusive of all taxes. Then very, very important is the customer care number. And this is very important, that complete things are required over there. Telephone number or a mobile number or an email ID, which is specific to the person who can be contacted, or the organization to be contacted over there. That should be clearly labeled over there. Legal metrology also demands these additional requirements of country of origin. So just stating the product, having UK mentioned over there, having the address is not country of origin. You have to clearly state, because you can be having an office in UK or an office in Germany, that is the selling place or the place of business in UK or Germany. It may not be country of origin. It can be a transit point, because you also have different definitions in these countries, like the legal manufacturer definition over there. So you may be making things in India or Taiwan or China and then selling over there without declaring country of origin. But if things are being shipped from there to India, India has to safeguard its consumers and make sure that country of origin is mentioned on that clearly. The size very relevant. Now size again very relevant, has to be in the matrix system. It cannot be in inches. And over here going forward, we'll have some questions and certain clarifications to seek from the representatives of the department. If dual scale may be permissible or dual description may be permissible, because sometimes that is a demand of the consumers and of the market, whether gauges can go alongside the matrix system or not. Then when you are changing the MRP or anything, and you're putting additional information, whether stickers are permissible or not. So stickers normally are, if you're going to be changing the MRP for an increase, normally not allowed. For decrease, it is allowed, but you need to put a logo over there so it knows that it becomes an authorized change. Your distributor is not doing an unauthorized change on your behalf. So here again, it is harmonized to the NPP requirements. And recently, just a few days back, there was a notification posted on the website which clarified this issue regarding the issue about the Essential Commodities Act. Then the issue also about the display panel and the minimum size of the letters, which has to come on the description, and how the declaration has to be made. So these are the ones which are critical to everybody. So be very careful about this and be alert about this. You may be having certain queries which you can raise in this seminar today. Experts are available from the 3 departments. Feel free to raise those questions over there and seek clarifications. Especially the main difference, let me tell you, from the point of persecution between both the laws. In the case of legal metrology, if something goes wrong, the inspector will raise a challan. So it's a compoundable offense. You will pay a fine and you will give an undertaking, and you will discipline yourself and discipline your employees that they will correct and make sure that the mistake will not be repeated. So if your mobile number is missing or telephone number is missing, email ID is missing, you correct that into your labeling requirement from the next batch, inform the department, and make sure it is not repeated again. But it's a compoundable offense. If this mistake happens of something which is missing from the point of view of CTSEO, then in that case, it's a bigger offense. It's a criminal offense. It's not a civil offense. A criminal offense under the case of mislabeling and misbranding. And over there, you can be persecuted and there can be court case against you. So be very, very careful about it, because until last year, hardly 30 medical devices were regulated under the Drugs Act. This year, practically every medical device will be regulated under the Drugs Act. Some already have been done. Until 1st April, the low-risk medical devices and the high-risk medical devices will be done from the 1st of October. But in any case, you have to seek registration before that and licensing before 1st October. So hardly with 2 months to go, be sure that you're compliant to that. With this, I would like to close my meeting, and I'm available for questions. And I hope you enjoy this webinar and the knowledge being given over here. Thank you so much.
Thank you, Rajiv Nathji, for a very brief summary and also comparing it with MDR rules requirements and the metrology requirements, which are very close to each other. I'm sure this will get elaborated by our next speaker. We have Mr. Ashutosh Agrawalji, who sent a message that he has also sent this presentation, and he said that he's going to be speaking on this topic, which he has been assigned. And I invite Mr. Ashutosh Agrawalji to speak on this particular topic, and requesting Aarti to please share the slides.
Thank you very much, sir. Thank you. Am I audible?
Yeah.
Yes, sir.
Thank you. Thank you very much, sir.
While the
Can
slides
somebody
are being uploaded, let me also tell the audience that Mr. Ashutosh Agrawalji comes from Department of Consumer Affairs. He is Deputy Director, Legal Metrology. We'll be hearing directly from him. It will immensely help everyone. Welcome, Mr. Ashutosh.
Thank you, sir.
One second, Agarwalji, she's just sharing the screen.
Please.
Just 1 second, please.
Any challenge, Ramaji?
No, just she's just sharing it.
Okay.
Not working, is it? 1 second.
I see a hand is raised, so we will take questions later on.
Yeah, sure. I think that's a good idea, sir. Meanwhile,
Sir, otherwise it is better to take the question first. It will be better. If somebody has any doubt about the legal methodology or any problem regarding the legal methodology, it will be better if we take the question first. No problem.
No, sir, there will be too many questions,
coming up,
and they may be part of your presentation in any case.
Good.
So
Yes.
let us finish our presentations and education part. If there are still residual questions, they can be taken up.
Yeah.
Thank you. Thank you. Next slide, please.
Aarti, can you make it full screen?
Full screen is
Okay. Go and share that the way you did it. That's fine.
Can you see full screen?
Now you can go full screen from here.
Thank you. Now I think it is okay.
Yes, sir.
Yeah. Can we move to the next slide, please?
Aarti, next slide, please.
Yes, it is necessary to print the MRP. See, as we are all aware. Thank you. See, if we talk about the legal methodology, the purpose of the legal methodology is to ensure the public guarantee from the point of view of security and accuracy of the payments and measurements. The purpose is whatsoever the quantity we are buying, we are getting from the market, it is correct. And this legal methodology starts from the birth to the death of a person. It basically creates a confidence in the trade industry and the consumer that whatsoever the quantity are being delivered through B2B or B2C, it is correct. It creates an environment for conducting business. Basically, if we talk about this legal methodology, the subject comes from the Constitution of India under entry list 50, which speaks about the establishment of standards of weights and measures, and under entry 33A, which speaks about weights and measures except establishment of standards. So basically, if we talk about the legal methodology, the responsibility of establishment of standards lies with the union government, and as far as its enforcement is concerned, it is being done with the state and the central government. So in this way, we are basically maintaining the law, we are making the law, we are making the standards of weights and measures, and we are regulating it in the country. Next slide, please.
Aarti, next slide, please.
Yeah, I've done it. Not.
It's not moving, yeah?
No, it's not moving.
No,
Yeah.
it hasn't moved, yes.
No, it is not moving.
Can you go to full screen? It's still not full screen, I guess.
Thank you. This, as we are all aware,
Yes.
this Legal Metrology Act, the first act, came into force in 1956, which was known as the Standards of Weights and Measures Act 1956. This act was repealed in 1976 by the Standards of Weights and Measures Act, and at the same time, in 1985, we were having the Standards of Weights and Measures Enforcement Act 1985. So with these two acts, we were regulating the standards of weights and measures in the country since 1976, which were repealed by the Legal Metrology Act 2009 from 1st of April 2011. The objective of this Legal Metrology Act is to establish the standards of weights and measures in the country. Whatsoever we talk that the units are also in the SI system of units, whether we talk about the units or we talk about the weighing instruments, we talk about any type of measuring instrument, they're all standards of, they are all covered under the standards of weights and measures. We regulate trended commerce in weights, measures, and other goods which are sold or distributed by weight, measure, or number. For example, any quantity, whatsoever the delivery, whatsoever the quantity is being delivered or the transaction is being taking place in the country, it is as per the Legal Metrology Act. It is either in the standards of weights, measures, or number. The Department of Consumer Affairs looks after these standards in the country. Next slide, please. As we are all aware, this standards of weight. Next slide, please.
Aarti, next slide, yes.
Yeah. Thank you. Thank you. This Legal Metrology Act 2009 is a very small and simple act. It only has 57 sanctions, and it is basically for the standardization of units of weights and measures based on metric system. Standardization of units of weights and measures is based on metric system, like length is in meter, mass is in kilogram, electric current is in ampere, time is in seconds. So like that, we have all type of standards of weights and measures which we have maintained. This Legal Metrology Act also requires few of the declarations on all pre-packaged commodities in the interest of consumers. The purpose is, when a consumer is buying a product from the market, he should be aware. He should know what product I'm buying, number one. And secondly, the very few information who has manufactured is, or whether it is imported or manufactured indigenously. All these things are basically required under these declarations. Many times we come to know, I don't know whether it is true or not. Somebody used to say that on the medicines, basically the strips, we do not have the consumer care details. As far as legal metrology is concerned, whatsoever the products which are covered under the legal metrology, they need to have the consumer care details, so that in case of any doubt or dispute, the consumer can directly talk with the manufacturer or the importer and can resolve his issue in place of making a litigation. We also need all type of weighing and measuring instruments which are being either manufactured in India or are imported into the country. They have the approval of models of their weights and measures. Basically, it is also required as far as these medical devices are concerned. Right now, we are regulating thermometers, blood pressure meters, and very soon EEG, ECG, a lot of other things we are considering. This act prohibits to manufacture, repair, or sale of any weight or measure without license. This act also requires that all type of weighing and measuring instruments which are manufactured or sold in the country, first time they need to be verified and stamped. Without verification and stamping, they are not allowed to be used or sold in the country. This verification also requires re-verification at a regular period of time. We also have the provision under the Act before this 2009 Act. All the directors of a company used to be booked for a violation, for an offense made by the company. But now, under this Act, this 2009 Act, we have a provision that a company can nominate any one of its director for making responsible under the Act. And in case of on any violation, that particular director will only be covered, or that will only be booked for this offense. Now all the directors don't have to run, and secondly, the compounding amount will also be taken from that nominated director, not from all the directors. We also have a provision of verification of weights and measures through the private parties like government approved test centers. Next slide, please. As we are all aware of metrology in India, we are basically the organizationally Metrology Legal. This organization is an intra-governmental organization which was established in 1955 and has its headquarters in Paris. We have 63 member states and 64 corresponding member states. India is the member, became its member in 1950. India became its member in 1956, and we also signed the Meter Convention in 1956. So Meter Convention actually was looked after by the National Physical Laboratory in India, and the legal metrology is looked after by the legal metrology in our country. The purpose of this OML, International Organization of Legal Metrology, is to harmonize the international or the national laws, so that whatsoever we are importing and exporting in different countries, they should also cover, or they should also have the same requirements as others have. I'm very happy to say that whatsoever the equipments, weighing and measuring instruments we are using in our country, they are all as per international standards. We are not compromising in the standards. They are very good instruments, whether they are the medical instruments, whether they are they are the instruments used in trade under the legal metrology. This commerce of weighing and measuring. So basically, we are harmonizing our national regulations also as per the international requirements. Next slide, please. Yes, there are many new weighing and measuring instruments which will come into the picture very soon. Like as far as medical devices are concerned, because moisture meter, if we talk about the pollution meter, if we talk about the breath analyzer, if we talk about the EEG, we talk about the ECG. Oh, many of the equipments are right now not covered under the legal metrology, which have to be brought under the provisions of the legal metrology, so that their accuracy can be ensured. As far as quality is concerned, BIS and many other organizations are regularly monitoring their accuracy, but for their measurements part, the legal metrology is only responsible to ensure that the equipment is correct or not. We used to have a control of these weighing and measuring instruments through the approval. First is the pattern approval, second is the verification and the re-verification. So this is the way how we are working in the country, not only in India, but at the international level. It is the same practice which is being monitored, which is being used in all over the world. Next slide, please. If we talk about the hierarchy in this legal metrology, we have that all the standards are starting from the international standard to the standards which are used, or the weighing and measuring instruments which are used at the commercial level by the traders. They are all have a traceability chain, and they are basically having they are having a chain of traceability with their accuracy or the permissible limits. First of all, we have the International Standard Act, PIPM, which is of the mass. Earlier, we were having the platinum iridium crystal, which was placed at Paris. Then we were having in India the nationalist where these weighing and measuring instruments are being kept. Then we have the
Mr. Agrawal, may I request you to switch off your video? I think there is a bandwidth issue.
original references standards
Your voice is breaking very often.
laboratories where these weighing and measuring instruments are. It will take 1 minute now. Now I have reached office. I'm sorry, I think.
Yeah,
Yeah. But it's okay, sir.
please continue.
I'm sorry. Now I have reached office. There should not be any problem. Thank you. Now bandwidth is okay. Voice is clear.
Yeah, very clear, sir.
Thank you. So with these international standards, we are having up to the commercial level. Next slide, please.
No, we are not able to hear you, sir.
Now are you able to hear me? Or otherwise?
Sir, voice is breaking.
think-
Maybe you can discontinue your video. Your bandwidth will improve, sir.
Okay, I'm just now joining from the computer.
Hello, Mr. Agrawal. Hello. Ramaji, I think he's not connected, right?
Oh, he's not connected, is it? Yes.
Yeah, I don't see him.
Manojji, can you please check with Agarwal?
Yes, ma'am. I'm
I
checking
guess-
with him. I'm
Yeah,
checking
maybe
with him.
some technical issue from his
So
end.
Yes, yes.
meanwhile, couple of questions.
I'm checking with him.
Yeah, please. Couple of questions, maybe one, but
So,
actually it's not.
One, Mr. R.D. Sharma is asking, we are providing address, email ID and phone number on the label. Is it okay, or should we also write name of the customer care officer? I think the answer is no.
He has joined.
Ma'am, he has joined.
He has joined, I guess.
Hello, sir. Yes. No, I will see him again. Ashutosh, sir, can you hear? Yes, he's there. Sir, you are mute.
Well,
It is better now.
okay,
Yes.
thank you. Thank you. I'm sorry. Thank you. Next slide, please. Sir, the weighing and measuring instruments which are covered under this legal metrology, we have few of the definitions. One is protection. Instrument for measurement like pressure meter, thermometer, person weighing machine, or a weighing machine which is used for manufacturing of the drugs. So all these type of equipments are covered under the definition of protection, and they need to be verified and stamped. Or the other type of equipments which are used for transaction, they also need to be verified and stamped. They are covered. Next slide, please. Seal, as we are all aware, it is a process by which, using a wire and the other material, we use to ensure that the stamp which is put on an equipment or somewhere, it is correct. Stamp, which basically it is a mark which is being placed or affixed on an equipment, ensuring that the equipment is correct. Next slide, please. Verification, comparing, checking, or just ensuring that an instrument which is correct with the standards is a verification. Label we used generally in the packaged commodities, that any type of declaration which we are making, it is either printed, graphic matter, marked, stamped, written, or affixed to, so that we can say that it is the label or it is the declaration of a commodity over which this particular label is being stamped. Next slide, please. Legal metrology, we have done few new recent developments for the ease of doing business. We have allowed all type of electronic products to give few of the declarations through QR code. We have also asked for the declaration of unit sale price, so that the consumer can compare the two commodities which are having different prices with the help of the unit sale price. Next slide, please. If we talk about this general rule, we have given some provisions. We have made some provisions in the interest of consumers. Earlier, only the directors of the companies were allowed to be registered or to be nominated for the violation of the under the legal metrology. Now, we have also allowed for the establishments and the branches that the other persons can also be nominated for the legal metrology to be responsible under the Act. We have also made few of the provisions that the weighing and measuring instruments which are not used, which are used by the industry for their internal use and are not used for any transitional protection, so that any weighing or measuring instrument which has been verified once does not need to be verified again before putting into use. So these are the few provisions in the interest of the industries we have been made. Next slide, please. We are also working on the very important project, which is the time dissemination project, that all in India we will be having one nation, one time very soon, that all the clocks are synchronized with one clock, national Indian Standard Time, and all of us will be having the same time. Next slide, please. These are the few rules which have been made under the legal metrology, which are basically packaged commodities rules and the general rules. Responsible general rules are measuring instruments, how a weighing or measuring instrument. So all these provisions are made under the general rules. And what are the declarations required? How the declarations will be made on a prepackaged commodity? They are made under the packaged commodities rules. There are approval of models, national standard, innovation, etc. Next slide, please. If we talk about section 2 under the legal metrology, that this is a commodity which in a package of whatever nature.
So your voice is breaking, sir. May I request you to turn off your video? Your bandwidth will increase.
Yes, sir.
Yes, sir.
Now I am audible, sir?
Yes, sir.
Okay. So section 12 basically prescribes. Section 12 defines the prepackaged commodity.
There are two connections from your side and it's
Yeah.
creating echo.
Remove.
Yes.
Yes. So section 12 prescribes about the definition of a prepackaged commodity. What is a prepackaged commodity? And section 2F provides what will be a label, how a label is defined. We have already discussed. Section 18(1)
provides for the declaration on a prepackaged commodity, and Section 18.2 provides that advertisements mentioning the retail sale price shall contain the net quantity or number contained in the package. And wherever we are making any declaration of any of the retail sale price, it also has a declaration of the net quantity. Next slide, please. Section 36 provides for the penalty provisions. If there is a provision, if there is a problem in declaration, then selling, manufacturing, packing, importing, distributing, delivering, or otherwise transferring, offering, exposing, or possessing for sale any prepackaged commodity which does not conform to the declarations of the package. In this case, the first offense is compounded at the cost of rupees 25,000. For the second offense, it is 50,000, and for the subsequent offense, the fine may be not less than 50,000, but it may go up to 1 lakh, or with imprisonment, which may be up to 1 year. Section 36(2) speaks about the error in net quantity or the short delivery. The fine in first offense is from rupees 10,000 to 50,000, and for the second and the subsequent offense, it may be from 50,000 to 1 lakh rupees, or the imprisonment up to 1 year, or with both. Next slide, please. The principal display panel in relation to a package means the total surface area. Many times we are in doubt that what is the principal display panel. As far as rules are concerned, it is very clear that the whole area of a packet, if I say this is a small packet, then the complete total surface area is known to be the principal display panel. The information could be grouped together and may be given at one place, and the pre-printed information may be given at one place, and the online information can be given at another place. So if all the informations are pre-printed, they have to be given at one place. And if the information is pre-printed and online, then it can be given at two places. At one place it is pre-printed, and at the another place it may be online. Next slide, please. These are the declarations which require on a prepackaged commodity: name and address of the manufacturer, packer or importer, country of origin, if it is an imported product, common or generic name of the commodity, net quantity in standard unit of weight, measure or number, MRP, which is inclusive of all taxes, unit sale price, month and year of manufacture, passed before or used by date, month and year, sizes or the dimensions of the commodity if relevant, and the consumer care details. So these are the few declarations which we require on a pre-packaged commodity in the interest of consumer, so that a consumer can take a decision or can take a decision for before buying a product. Next slide, please. For the e-commerce entities also, we require to give some few of the declarations. It is from 1st of January 2018, name and address of the manufacturer or the importer, country of origin if it is imported, common or generic name of the commodity, net quantity in standard units of weights, measures or number, MRP, passed before or used by date, month and year. So these are the few declarations which also require to be given on online sites or on e-commerce entities. I don't know, but many times it is observed that on e-commerce sites, the prices are less, or they are giving discounts, which again creates a problem for the sellers who are selling through the shops. So we have to look into it, that how this can they can be also with the competitive prices. Next slide, please. E-commerce entity has to ensure that all the mandatory informations are given on their websites, which is basically the responsibility lies with both the e-commerce entity as well as the seller who is selling his product on the e-commerce sites. Next slide, please. E-commerce entity has to ensure that it is providing the access to the seller to make the declarations on their sites. But it is also the responsibility of the e-commerce websites that they should ensure, without giving all the declarations, products should not be uploaded on their sites. For example, if we are selling the weighing and measuring instruments which are not verified and stamped, and they are selling, then it's again a violation. And we have issued large number of notices to e-commerce sites as well as the sellers who are selling these products on their sites. Next slide, please. This is the size of the declarations. If we talk about the principal display panel, that is the total surface area of the package is less than 50 square centimeter, then the size of the height of the numeral letter should be at least 1 millimeter. If it is printed and if it is molded or blown or formed, it is required up to 2 mm. It is required for 2 mm. If the sizes are from 50 to 100, so this is a way how the rules specifies what will be the size of declaration on a prepackaged commodity. If the size is small or if the letters are small, but when the size is big, it can be seen from the far off distance, and that's why all these declarations are required in this. Next slide, please. There are few provisions of the legal metrology that no person, previous slide. Sorry, yeah, no person or retail dealer, including manufacturer, packer, importer, will make any commodity over and above the MRP. And we used to get large number of complaints that the selling prices are different, and the shopkeepers are selling at the prices which are more than the MRP. And we used to take action as per the law. We also have a provision that there should not be two different MRPs, or we can say differential prices on an identical prepackaged commodity. It also does not allow to alter the price once clear. It also requires that all the manufacturers, packers, and importers of any prepackaged commodity, they need to register themselves on the with the legal metrology. At the central level, we have made a portal NSWS. Yeah, please, I'm sorry. I'm sorry. We have a central portal at the central level, which is nsws.gov.in, and anybody who wants to register themselves under Rule 27 as a manufacturer, packer, or importer, he can apply on this portal NSWS under the Consumer Affairs Department for registration of prepackaged commodity. Next slide, please. These are the maximum permissible errors allowed in case of the prepackaged commodities. If the quantity declared in a package is 50 ml or 50 gram, the maximum permissible error allowed is 9 gram. Similarly, 9%. And if we talk about 100 gram or 100 ml, the error allowed is 4.5 gram or 4.5 ml. So this is the way how these rules prescribes how much maximum permissible error is allowed in case of the prepackaged commodities. And all these things are taken from the international level. Nothing is being made at our own level. Next slide, please. These are the few recent amendments which we have made. For example, if we talk that earlier it was necessary to have 19 commodities in the prescribed sizes, we have just done away with this rule, and now all the commodities can be packed by the manufacturers, the packers, as per their own requirement or as per their own wish. We also have the requirement for month and year of manufacture only, which will come to soon, will come in force from 1st of September. MRP is basically the maximum retail price, which is inclusive of all taxes in Indian currency. Many times it is observed that when we are taking food in the hotel or the restaurant, they put the tax or the GST on the water bottle, which is already covered with the taxes. So these things can be avoided. Next slide, please. Unit sale price was introduced under this Rule 6 as Rule 611 by this amendment. Sorry, please, last slide. And this unit sale price is very important. Last slide, please. Yes. Anyway, leave it. So these are the few provisions which we have already discussed, that for the electronic products, we have already allowed QR code. They can use this. Unit sale price is introduced since 2011, which is many of the companies are already declaring the unit sale price. You have seen that price per gram or per ml or per number is being mentioned on the prepackaged commodity. It is in the interest of consumers to just compare the prices of two different commodities having different quantities. Next slide, please. Garment or hosiery, we are all aware that a few of the declarations we have asked, otherwise the rest of the declarations when they are selling in open are not required. Next slide, please. We have already discussed that for the different establishments or branches, we can nominate other persons also. Next slide, please. E-commerce entities have been requested to display all these mandatory information under the packaged commodity on all prepackaged commodities at one place. Foreign country's name mandated under the law should be in full form. To make a provision that sites could not be e-commerce website number e-commerce websites so that sellers should be able to upload their products with the mandatory declaration only. For non-compliance, notices have been issued, and for non-compliance of provisions and rules for weighing machines also, we have issued the notices, and we have also covered the compounding amount. For those cases which have not been compounded, we are putting them into the code of law. Next slide, please. These are the medical devices. Basically, as we are all aware, before this amendment in 2017, which came into force from 1st of January 2018, the medical devices which were declared as drugs are covered under the legal metrology. Before that, the medical devices were covered, but the medical devices which are declared as drugs were exempted. So there is a very small change under these rules from 1st of January 2018. Before that, all the medical devices which were not drugs were covered under the rules. We have also requested the state governments to allow the increase in prices if wherever required, and they are being allowed by any government, by the government or by the NPP or any statutory body that these prices can be revised, because there was some problem in few of the states that state governments were not considering, and they were taking that the prices revision in the prices or to change the prices is not allowed. So this is the way how we are working in the country with the legal metrology. This is, I think, these are the few things which I wanted to share with you. Next. I think this is enough. Thank you very much. Thank you. Thank you. I would like to thank the MID to give me this opportunity to speak and organize this program. I'm very sorry, due to this a lot of other things I could not make. I'm sorry, I could not justify the position. But certainly in the next time on future, wherever required, I'm always available. Thank you. Thank you very much, sir. Thank you. Now, any of the questions if anybody wants to ask.
Thanks, Ashutoshi. We have lots of questions in the chat box and question answer session.
Please.
And we would definitely be asking those questions. But since we had to kind of let go some of the time during your presentation,
Please.
Let us go straight to Asim Sahu sir and let's listen to him. And then we'll go to Simiji and then question answer session. Many questions have already been answered in your presentation, but there are a couple of good questions I've written down and we'll open it up a little later. Asim sir.
Sir.
So can you go full screen, sir?
Yeah.
Thank you.
Now it is visible to full screen, sir?
Very visible, sir.
Yeah, sir. Once again, good afternoon, sir. And thank you for giving the opportunity. And I welcome all the stakeholders, participants, speakers for this special webinar for the stakeholders. It is very good steps what that CC Secretariat and IMED has organized. The responsibility which the sponsor has given me to give the overview on the medical device regulatory framework, and it's my pleasure to be here and give this presentation. I would cover these four. I have that because the time is very limited, so I have shortcut that my presentation, and my presentation would cover the overview that we all aware of, the overview of the medical device industry. What is the industry? What is the position of the industry? Regulatory framework, brief overview. I will share that your medical device rule and the recent amendments what we have incorporated after implementation of the MDR 2017. So this is the industry side. I will not take much time because industry is well aware of the industry size, but growth rate, that is the important factor. You just see the growth rate of this industry is 14% as per the CAGR. That very significant growth is there in the country. The dependency right now we have in the field of the disposable and some implantable devices, disposable syringes, needles, cannula, perfusion sets. We have built up that capability. Mostly that our industry are in the disposable only, and certain industry that are in the orthopedic implants and cardiac stents. This industry is highly capital intensive and long gestation period and require a lot of the development and induction of the new technology. So continuous training to the healthcare provider to be adopted to adopt the new technology. And also we know that the industry is totally dependency on the import, and more than 75%. You can say 80% of the products are being imported into the country, and only the 20% of the market is shared by the indigenous manufacturers. And most of the high-end medical devices are imported into the country. We don't have such that capability right now. If we talk about the rules, the Drugs and Cosmetic Act 1940, that is the present act. The present act, under this act, we are regulating the medical devices. As we all aware, this act is the central act. It is enforced by both the state as well as the central authority. And the objective of this act to regulate the import, manufacture, sale, distribution of the drugs and cosmetics. Is under the definition of the drugs, the medical devices are now presently regulated. And since the medical device, the drugs and cosmetic rule does not have the specific provision for requirement of the medical devices for its import or the manufacture or the quality management system or the clinical investigation, that we have, based on the support of the industry and the concern of the industry, that government has come up with the medical device rule 2017, which is implemented with effect from the 1st of January 2010. And now we have implemented since last 6 years this medical device rule 2017. Under this rule, that specific requirement for the import, for the manufacturing, for the conduct of the clinical investigations, for your sale and distribution, that provision we have made so as to segregate the requirement, because we all aware the medical devices is a complex in nature. It is not, we cannot equate with the drugs. So requirements are entirely different. Thereby we have that come up with the new provision where we have made the specific requirement for the import and market as well as the clinical investigation of the medical devices. And this medical device rule, if you see, it is at par with the globally accepted requirements. And we have made all the provisions which is in the line of the globally accepted best practices. And if you see the genesis, the history of this medical device regulation, we all aware till 2017 we don't have the specific requirement. And also I can say that by 2020 we don't have the provision to regulate all the types of the medical devices. Now if you see the history, the first medical devices was notification was published in the February 1983, where we have made the provision in the definition of the drugs to incorporate the medical devices. Before that, there is no provision for the medical devices. Under the definition of section 3B of the drugs, 3B4 we have added in the year 1983. Thereafter, in 1989, only 3 medical devices have been notified for regulation. Then concept of the good manufacturing practices, 94. Thereafter, 2002, we have notified 4 different high risk in vitro diagnostics. Then in 2005, we have notified 10 medical devices. Then 16.1, Then again, M3 has been revised with the incorporation of the quality management system in 2016. Then new rule, as already we are aware of that, this new rule was published in the year 2017 and effective from the 1st January 2018. Thereafter, again, by that time we have notified certain medical devices. Then thereafter, some 14 more category of the medical devices we have notified for its regulation. Now, finally, in February 2020, we have notified the definition itself under the provision under the definition of the drugs, that is the part 3B4. And once that definition has been notified, that all the medical device comes under the regulation of this act. And what is the definition which we have notified? This definition already all that we all are aware. This is the globally accepted definition for the medical devices, because in the act we don't have the provision to have the separate. It will take time. That's why what the government had decided to notify the definition of the medical devices to cover all the our medical devices. And the definition, I am not going through the definition because all are aware what are the definition of the medical devices globally, and it is in the same line. So there is no any major the difference. You will see the definition, and by this definition, now at present all the types of the medical devices, irrespective of the category, are comes under the regulations, and this regulation is adopted in a phased-wise manner for the devices which is not previously regulated. If you see the medical device rule 2017, this rule have the total 12 chapters. Total 97 rules have been incorporated and 8 schedules are there, and total forms, 43 different forms are there, which relates to your import, manufacture, clinical investigation, and all those things. If we go by the chapter one by one, the chapter 1, it is the preliminary chapter that title, application, and commencement of the and definition also we have been included in this chapters. Chapter 2, where the provision for the classification, grouping, essential principles, and standards, we have made the provisions. Chapter 3, which have the provision for the authority responsible for various activity under the medical device rule. Chapter 4, it is the requirement of the sale and manufacture, sale and distribution of the medical devices, where how to obtain the, what is the provision for obtaining the manufacturing license, what is the validity, what are the requirement, all those provision we have made under the chapter 4. Chapter 5 mainly focus on the import of the medical devices, where also the same provision for requirement of the applications, technical documents, the licenses we have made. The labeling requirement, the chapter 6, where the detailed labeling requirement was prescribed. The detailed labeling requirement already Rajiv Nasab has briefed that. What are the mandatory requirements provided in the chapter 6 of the medical device rule. Chapter 7, which have the provision for the conduct of the clinical investigation, what are the requirements, how to go, take the permission from the authority, it is provision has been made. Chapter 8, that is the provision where the device is first time, if it is to be marketed in the country, whether it is import or the manufacturer, the requirement is prescribed in the chapter 8. Chapter 9, the duties of the authorities, that is medical device officer, medical device testing officer, and also the notified body. Chapter 10, that is the registration of laboratory, where the this private testing laboratory can register with the CDSO, and they can conduct the various tests as per their approval obtained from the authority, and they can conduct this test on behalf of the manufacturers. Chapter 11 is the sale of the medical devices. What are the requirement? And chapter 12, that is the miscellaneous, where we have made the provision for exemptions, certain export requirement, mode of the payment, debarment, all those things we have made in these chapters. So total 12 chapters for the different component we have incorporated in the medical device rule. And enabling this provision, we have also come up with the schedules, and total 8. schedule have been incorporated, and each schedule, the first schedule, if you see, these schedules gives you details of the criteria of the classification of the medical devices as well as the in vitro diagnostic. What are the criteria based on which the authority can be classified the devices? That provision has been made in the first schedule. Second schedule, the fee structure for the various provisions of the requirement, like your import license, manufacturing license, and all those details have been given. Third schedule, that is the document required for the notification of the for registration of the notified body. What are the duty? What are the functions? That details have been provided in the third schedule of the medical device rule 2017. And also, it is just I want to share that the notified body which is only registered with the CDSCO is responsible for audit of the low risk devices, that is only class A and class B. For high risk, the central authority has the power to notified body's role as clearly defined in the medical device rule, and what are the registration requirements, that details have been given in the third schedule. Fourth schedule, that gives the detailed document requirement. What are the document required to be submitted by the manufacturers or the importers for grant of the manufacturing license or the import license. Fifth schedule, that we have made the provision for the quality management system. It is in the line of 13485, and the manufacturing facility who is going to manufacture the medical device in the country, the facility should have the quality management system in their premises, and the requirement is prescribed. This quality management system is to be verified for low risk by the notified body, and for high risk from the Central Licensing Authority. Sixth schedule, that gives the details of the post-approval changes, which changes classified under the minor and which are the major, that clearly we have defined. And for the major, the approval is necessary, that also provision have been made, so that the applicant can have the clear-cut idea which changes they require to notify and which changes they require to take the permission from the licensing authority. Seventh schedule, that gives the requirement for grant of the import or the manufacturing license of the investigational medical devices or the new in vitro medical devices. And eighth schedule, we have given certain exemptions for certain category of the devices, like custom made. There is a certain exemptions for the licensing and the manufacturing, or the for sale for your certain products. We have given exemption for the requirement of the sale license. So certain exemptions we have given, and the details have been prescribed in the eighth schedule of the medical device rule. As already that I have briefed this rule, the risk-based classification we have adopted, where the low risk devices classified under class A and high risk medical devices is classified under class B. Class B considered as a low to moderate, and class C considered as a moderate to high risk. So based on the risk of the devices, the requirements are also we have defined separately. Low risk, devices, low requirement is made, provision have been made. High risk, the more that critical and that clinical data that need to be submitted at the time of grant of the approval or the permission of the devices. So based on the risk, the criteria has been defined how to classify the devices. Clearly, we have made in the first schedule of the medical device rule, and the classification, as far as the classification of the medical devices are concerned, it is the discretion of the Central Licensing Authority. Central Licensing Authority, based on the intended use and their characteristic, they will classify as per the first schedule of the medical device rule, and they will publish the classification list on the website of the CDSCO, so that the stakeholders can submit the application based on the risk of the classes of the devices. It is not the discretion of the manufacturer that they can themselves classify their devices. Labeling provisions, what are the labeling provisions for the medical devices and in vitro diagnostic kits for domestic market? It is mentioned in the rule 44 of the medical device rule 2017, and the details already Mr. Rajiv Nath has explained very clearly, so I will not give them much time. The detailed information, that like name of the devices, name of the manufacturer's statement about the quantity, date of expiry, date of manufacturing, batch numbers, is storage condition if it is applicable, whether it is supply sterile or non-sterile, whether it is supply by for the physician sample as a physician sample, or whether some if it is a manufacturing license, then they need to mention the manufacturing license number on the label of the product. In case of imported devices, certain information they can put on the label of the devices by way of the stickering. So, and the various that international nomenclature, they can also adopt it while complying the requirement for the labeling requirement for the medical devices. So that provision we have made under the medical device rules. The regulatory responsibility also clearly defined in the medical device rule 2017, where the import all the class of the medical devices, the central licensing is the authority for grant of the import license for medical devices, and the central licensing authority, headquarter, is taking that responsibility. Manufacturing for low risk class of the medical devices like class A and class B, the state licensing authority is responsible for the grant of the manufacturing license. And for high risk, that is C and D, central licensing authority is responsible for the grant of the manufacturing license. For conduct of the clinical investigation or clinical performance evaluation, the permission is to be issued by the central licensing authority. The sales responsibilities lies with the state licensing authority. Quality management system verification, already I have explained, for low risk class A and class B devices. The QMS audit is being done by the notified body. Notified body means the notified body which is registered with the CDSO. They are eligible to evaluate, to verify the quality management system. And for the class A and class B medical device manufacturers. And for high risk class, the central licensing authority is responsible for audit of that facility, and based on the satisfactory compliance of the quality management system, license is granted by the concerned authority. Already that I have given in the previous slide. This is the same repeated slide, where the responsibility of the central licensing authority as well as the state licensing authority, as per the medical device rule, we have that. I have just briefed here only. Notified body, the role of the notified body, also I have explained that it has to be registered with the CDSO. The criteria is that has to be accredited by the NABCB first, then there are certain requirements. They need to submit the application with the CDSO. After satisfying, the notified body is registered with the authority, and then they can their facility, their expertise can be utilized by the state authority while granting the manufacturing license and the quality management system conformance. And total 13 notified body we are so far registered for this purpose. For the testing central labs, total 6 central labs so far we have notified for carry out the different test of the different category of medical devices, but there is a lot of challenges for testing. And slowly that we are come up with the, we are going to have the more establishment of the new testing labs for testing so as to cover testing of more all the almost high-end medical devices also. Also the 35 total private medical device testing center we have registered so far to carry out the testing of the medical devices and in vitro diagnostics on behalf of the manufacturers. Salient points that already I have explained, but it is just I will convey briefly that certain more definition related to the medical devices we have incorporated. Risk-based classification we have adopted, provision for essential principle, product standard, shelf life of the medical devices, that provision we have made. Registration and import license, that we have only these two activity we have clubbed together, and now we have made provision for the import license only for import and marketing of the products. Submission of the all document we have made the provision through online, so no physical submission is there. we have given the specific timeline for each of the different activity under the medical device rule 2017. Scope of the notified body we have defined, and we have made that provisions. Requirement of the post approval also we have made that provision, and clinical investigations, and also to have the better ecosystem, that the concept of the perpetuity in the license that we have made, and the license are issued in perpetuity provided they need to submit the existing license. So to maintain the continuity, it is not the manufacturers or the importers, they need to submit all the technical documents. Only the minimum fees and the sort of the certification or undertaking they need to submit it while taking the continuity of their license. In case there is a major changes, then only they need to submit the requisite document as per the requirement, but the license are issued in perpetuity. For low risk devices, we have made that provision, no prior inspection is mandatory. The application will be given once it is submitted within a particular time, and they can manufacture. However, the certain period, the inspection is to be carried out to verify the quality management system. Provision of the loan license we have made in the medical device rule, where the license facility, the loaning firm, they can obtain the avail the facility of manufacturing for manufacturing of their own product by way of the licensing system, loan licensing system. For high risk, the Central Licensing Authority had taken the responsibility for the grant of the manufacturing license. Test license to develop the medical devices for the testing purpose, because they at the initial stage, without license, no medical devices can be manufactured. If they want to develop the product, they need to take the license. So it's very difficult initial stage to obtain the license. So that provision we have made, where the limited quantity of the medical devices can be manufactured or the imported into the country for test and evaluation, and thereafter they can generate the data and submit the authority for necessary regulatory approval for commercialization of their products. The rationalization of the shelf life, we have made the provision for the imported medical devices, where the low shelf life of the product, where the shelf life is less than 6 months, we have given the residual shelf life of 40%. If it is a 1 year, then we have given the residual shelf life of 50% more. If it is a more than 1 year, then the residual shelf life 60% will be allowed into the country for import. This is only actually applicable for the imported medical devices. For regulators, that we have made the provision for the establishment of designation of the government laboratory, and under these provisions we have notified 6 central labs, and also for the state testing laboratory we have given the provision, and the state licensing authority is also going to notify their state labs for the purpose of testing of the medical devices. For the manufacturers, the private provision for the private testing laboratory for testing of the medical devices has been made. And also, as already I have explained, that the total more than 30 testing centers so far we have approved for this purpose. The provision for the debarment of the applicant or the rejection of the application, and also the provision for the grant of the free sale certificate for the export purpose. That specific provision we have made in this medical device rule 2017. Subsequent to that medical device rule implementations, various amendments from time to time also we have done, and already I have explained that 2020 that the notification has been published where the definition of the medical device has been notified, and there's another notification has come where we have notified all the devices, and phased wise that regulatory pathway we have made the provision, and accordingly the devices, low risk devices, which devices has come the regulatory regime from the October 2022. Now the October 2023, the new high risk medical devices are come under the license regime, and the stakeholders are well aware of that, and they need to they are fulfilling the requirement before the implementation of this provision of the rules. Also, we have made that amendment, and we have made the provision for grant of the registration certificate for sale and distribution of the medical devices, because earlier the requirement of the drug sale license is there. But if the manufacturer, if the trader is required to distribute the medical device only, then they can take that registration certificate on the concerned state authority, and they can stock and distribute the their medical devices where they are going to sell the product into the market. That provision we have made. Certain exemption also we have given recently, that for the non-sterile, non-measurable medical devices, the licensing requirement we have exempted, and they need to register with the authority. Whatever the product they are going to import, then registration provision is already made in the medical device online portals. And also for the state, that notification has come where they can establish or they can designate their state laboratory for the purpose of testing of the medical devices. So these are the various measures that amendment we have made in the medical device rule 2017, and also to have the more clarity on the rules and requirements, a certain guidance document and FAQ has been published on the website, so that stakeholder may have more clarity on the requirement. Some certain that document, that the classification list, it is available. Guidance document for free sale, guidance document for performance solution of the in vitro diagnostics, grouping of the medical devices, guidelines for the essential principles for safety and performance, medical device adverse reporting forms, central laboratory testing, identify for testing of the medical devices, FAQ with respect to the in vitro diagnostics and the medical devices we have made so that the stakeholder can have the more clarity on the particular issues. And these documents are dynamic, so from time to time we are updating based on the concern received from the industry. The notified body which is registered, it is already available to have the reference purpose. The people can know what are the notified body who is eligible for the audit of the class A and class B medical device manufacturing unit. The medical device testing center labs, so whatever the notified by the Ministry of Health Family Welfare, it is also listed in the website of the CDSO. The labs which is registered, it is also there. Other documents already it is available on the website, and whatever the certain clarification by way of the circular also we are uploading. So these are the some overview on the present medical device rule 2017, and because of the time I have not given that much and not going to the deep. So this is all about the medical device rule. Whatever that concern, if it is there, then definitely I will ready to give that answer. Thank you very much for your kind attention. Thank you very much.
Thank you, Asim sir. You have run through the medical device rules, and I can see there were a lot of questions about the rules, which people must have got answers. We'll take up the specific ones later. Now I invite Ms. Simi to share her views. And Ms. Simi, do you have slides?
No, I'll just.
Okay,
stop.
all right. You're welcome. Ramaji,
Yeah.
can we pin her so that she is on the screen?
Okay, sir.
Good evening, all. I thank the organizers for inviting CUTS International and giving us an opportunity to share the consumer viewpoint on the.
Sir, you can stop sharing. Sorry, Simiji, I disturbed you. Please
Yeah, that's fine. So yes, the decision to mandatory include essential product information and consumer care details on medical devices is certainly a significant step in empowering consumers and protecting their rights. As a consumer organization, we truly believe this move will greatly improve the overall consumer experience and tackle some of the pressing issues that consumers face in the medical device market. To put it more precisely, first, it would ensure transparency and informed choices, which are crucial while making any purchasing decisions. With access to such vital information, consumers will get an opportunity to compare prices, access the product origins, evaluate its suitability for their specific individual needs, and so on. Second, it would also help ensure fair pricing practices. and ensure that consumers are protected from unsurplus pricing practices, which have been a concern for a long time. In fact, such measures are vital in not only promoting fair competition in the medical device market, but to also manage supply of such products effectively during pandemic-like situations, where often it is seen that consumers get victimized due to price exploitation. Third, it also helps in combating misleading practices by mandating that the medical devices include care information on the packaging. Consumers can better understand the proper use, maintenance, and potential risk associated with the product. This will minimize the chances of falling victims to false claims, thereby ensuring consumer safety and well-being. Besides, the extension of provision to cover the sale of products sold through e-commerce platform is also a welcome move. As consumers increasingly rely on online shopping for convenience, it is essential that the same level of protection and information is available to them regardless of the mode of purchase. It reinforces the principles of equal rights for all consumers, regardless of where they make their purchases. And more importantly, such labeling requirements could also play a crucial role in reducing medical waste. Statistics shows that the healthcare industry produces a huge amount of waste each year, especially since the COVID-19, and a large part of that waste is made up of medical devices, which can be everything from even an examination glove to syringes. So with correct labels affixed to them, safe disposal becomes a lot easier for all, and it would also encourage product reuse wherever applicable. Such labeling requirements are quite in practice in other countries. For instance, in Japan, the labeling requirement for medical devices mandate displaying essential information in Japanese, and this information includes product name, price, market authorization, holder name and address, usage instructions, precautions, manufacturing date or expiration, and storage conditions, among many others. Likewise, the Brazilian Customer Protection Code also requires that product labeling provides the consumer with correct, clear, precise, and easily readable information about issues like product quality, quantity, composition, price, guarantee, shelf life, origin, and risk to consumers' health and safety. And in US, the US Food and Drug Administration set these rules and enforces them. It usually contains a lot of text such as details about how the device should be used and information on what it contains or the company that made it. Likewise, in Europe, EU medical device regulation has been applicable in EU member states. It mandates that in Europe, all medical devices must bear a label identifying the name and address of the manufacturer, including operating instructions, warnings, or precautions to take. And also, there are many other requirements in EU. So the decision taken by the Department of Consumer Affairs that all medical devices must contain a requisite information and consumer care information on product package is not something new. However, when we look into the merits of this decision, it is also essential to acknowledge that there are some certain challenges which our country may face while complying with this decision. One of the most significant challenges we would face would be ensuring the effective implementation and enforcement of the mandate across the entire medical device industry. Ensuring that all medical devices comply with new packaging requirement and that the necessary information is accurately provided may pose significant administrative challenge. Also, monitoring such compliance across various online platforms would also be a resource intensive and complex challenge. Likewise, small manufacturers, especially those operating at a local or regional level, may face difficulties in complying with new requirements. They may lack the resources, expertise, or awareness needed to implement the changes effectively. And definitely webinars like these would guide them. But still, special attention and support would be necessary to help these manufacturers meet the packaging guidelines. Then ensuring the accuracy and reliability of the information provided on medical device packages will also prove to be painstaking, ensuring that every single information provided are up to date, verifiable, and it is like consistent across all packages can be challenging, particularly when dealing with a vast array of products from various manufacturers. Another concern is without proper checks and balance put in place, this decision may unintentionally lead to increased corrupt practices, because there are apprehensions raised by few experts across various news articles, because currently under the existing legislation, first-time offenders face a monetary penalty, while subsequent violations could result in imprisonment along with fines. This power dynamics between the local inspectors and the entrepreneurs has always been criticized, as it creates disparity between the as it creates opportunity for corruption. In fact, recent data highlighted in a news article showed a significant disparity between the number of first and second offense booked under the LMA, raising concerns about its effectiveness in deterring violations. This is one of the reasons why we are raising this concern, actually, because in 2018-19, according to that news article, the number of first offense booked under the LMA was 1,13,000 something, but for the second offense, it was only 12. So, and the same goes for the consecutives. While the first offense booked was in lakhs, the second offense booked were only in single digits or just a bit more. So that is also one of the serious challenges which the regulators need to look into how to tackle it. Besides, the success of decision depends on consumers being aware of their rights and the information available on medical device packages. So educating the public about the significance of the information provided and how it can benefit them is essential, especially given that in India, a huge number of rural and urban consumers are there, and everyone would not be as good as in reading English. So language barrier will also act as a significant challenge here. So to conclude, while decision to mandate information on medical device packages is undoubtedly a positive step for consumer protection, the country will need to address some of these challenges to ensure a successful implementation. Thank you.
Thank you. Thank you, Simiji. You have brought in a very different perspective along with the mandatory labeling requirement into different regulated zones. I think you complete the circle with what Rajiv ji started in the beginning. And a general comment for everyone is that a lot of labeling compliance, whether it is local regulation or international regulation, you are very close to the compliance with your these requirements. So there, if you study the rules, there are a lot of questions in the chat, in the question answer session. If you study the rules carefully, a lot of answers will be available there. However, because of paucity of time, I picked up a couple of them, which I really liked very much. One of the important question, any of the speaker can answer this is, if there are symbols used on the medical device labeling, which is like, for example, a manufacturer, there is a symbol, for manufacturing date, there is a symbol, but these symbols are not specified in these rules of legal metrology. So is it required that we use symbol because that compliance is required in ISO and in medical device rules or international regulation? Along with this, do we have to use the words like date of manufacturing along with symbol? This reduces the space further. So anyone can answer that. Maybe I'll go to Ashutosh first, if he's got an answer to this.
Thank you very much, sir. Sir, as far as are you asking about the caption heading?
Symbols.
No, symbol is for what? Symbol is for a declaration of month and year. That means 2nd November 2023. like that, or you are asking the caption, month and year?
Caption, sir, caption, date of.
Sir, as far as legal metrology is, sir, as
we
far as
write a
legal,
symbol.
yeah, now I got your point, sir. As far as legal metrology is concerned, we are never asking what caption you are giving. No one rule. We are asking about the declaration, month and year of manufacture. The 2nd November 2023. Finish. So whether you are putting the symbol, whether you're writing the words, legal metrology is nowhere restricting to make any type of symbol.
Maybe I would like to hear Rajiv ji on this. What is his opinion on this?
Yeah, this is a gray area because to our understanding, there'll be a challan in case somebody puts a symbol of expiry date and not put the word expiry over there. So while CDSCO MDR permits this, legal metrology seeks no substitution of their legal labeling requirements like B number, lot number, batch number with the symbol of the batch number, for example. Or if they want manufactured by, you can't substitute manufactured by a logo of manufacturing symbol in ISO. So in that respect, as manufacturers, we are forced to do both. But sometimes, yes, in a small pack, it becomes a challenge to comply with both the requirements. So in many cases, sometimes we then forego the symbol because the legal requirement is more strict than the symbol which is required internationally.
Thank you. Thank you, sir. Maybe, sir, we have a point of request to Department of Consumer Affairs that they can probably think about it if symbols can be accepted, in terms of
Sure.
we can really provide that information to the department so that they can think of alignment.
No
Allow me to move to the
also
next
think,
question.
Mr.
Yes, sir.
Agarwal, I also think, Mr. Agarwal, that there is a need to harmonize the requirements between both the regulations.
Agreed.
So what is missing in the medical device rules, they need to consider to add that for the patient consumer's benefit and manufacturer's benefit. And similarly, the provisions which are available for patient safety may be also required for consumer protection in your rule book over there. So there's a need to, I think, harmonize both the sides.
Agreed.
This is one part. I'll give you one question, for example, on behalf of everybody. The normal pitch problem that comes up for many challans is the question of dual scale. So normally in most of the products, the doctors and manufacturers are used to using the gauge scale. So 18 gauge into 1 inch needle, for example, or 16 gauge catheter, for example. And so manufacturers are putting normally both. So both millimeters by the metric system as well as in inches. But many of the inspectors, when they see the word inch or the sign of the quotation mark, which is substitute for the inch, they will create a challan. So either there needs to be a clarity or there needs to be a concession that millimeter is what is important, is already over there. The country will take some time to transition from the British system to the metric system. Till now, let us be practical. For thermometer, for temperature, we will still talk that 99 degree, 100 degree is fever. And people will not be clear that 36 degrees centigrade or 40 degrees centigrade is fever or not. So dual scale, we think sometimes may be permissible, and there should be concessional provisions for that. Unless there is a very strong feeling of continuing doing away with the dual system, and then something like this, a webinar may be used to explain with the reasons why. I'm sure the consumers representative, Madam Simiji, will also have an opinion on this, but this is a typical area where it becomes a pain point for manufacturers when we get unnecessary challans. And one of the questions I noticed over here also was, if I can ask Dr. Sanjeev on their behalf, you mentioned, Mr. Agarwal, regarding challan should be against one particular director, notified representative director. But many times in certain states, they are asking for multiple challans and they ask list of directors and they want to raise challan against each director. Now, that's an overkill kind of a thing. So if you could kindly give clarity on that, and then we could inform our IMET members on that. And if there is somebody who is insisting, any inspector, then we can come back to you on that for the particular states, so that you can kindly educate that state's regulatory body.
Yes, sir. I think you have raised, I think all the very important issues you have raised. The one is nominated director. It is very clear. Suppose I will issue a notice to any of the company. I'm just taking my example. I will ask the first question, give me the list of all the directors. At that time, the company has to inform that this particular director is already nominated for this particular Legal Metrology Act. And that's why he just have to provide that detail only. They're not, at that time, the officer or the state government inspector will not ask the details of other directors as per the law. Number one. Second is symbol. Sir, unfortunately or fortunately, what we should say, we are actually the Meter Convention signatory country since 1956. And now it is 2023, more than 70 years. And if we say that, no, we will continue with inch, foot, and like that, I think we have to change our mind. What the law says, if you are declaring in millimeter, and with this millimeter, within bracket, if you also put in another unit without declaring that unit, that means you are putting 12, but not writing inch, then there will be no problem. He will continue, but then how the person will understand what is its unit? Again, the same problem will come with the consumer. So my request will be, if the industry actually feels that it is very strong requirement, then you kindly give us this representation. What we'll do, we will consider it. Certainly, why not? If this is a requirement of our own country, our own indigenously manufactured industry, why we will not consider? We will 100% consider. Secondly, the most important part is the awareness. As far as most of the members will not be aware of the provisions of law. At the same time, our own officers are also not updated. And that responsibility lies upon your and my shoulder. So we cannot run away with our responsibility. We will do it. And my request will be this time. See, every Saturday I used to organize one seminar, one workshop for 2 hours. Since last more than 2 years, I'm doing that. Why? To just create an awareness, just to make informed the consumer, the industry, the officer. This is the only purpose. So we are trying to do this, and with the help of you, because you are a known figure in the country and in this particular industry. But why you're not going to today's program of the Prime Minister? You're not going to in the today's program?
This was more important.
Oh, okay. That
Just
is
taking a picture with the Prime Minister is not important. This is more important.
Okay. Okay. All right. So now the point is, so as far as this inches and other units are concerned, if you feel there is a strong requirement, kindly let us know. We will again examine, and we will reach with your consultation to an amicable solution where we can say yes, win-win situation. Neither industry is harassed nor the law is harassed. This is another point. Third one, what do you say about the symbol of declarations under the legal methodology? It never asks that what you have to write, manufacturing date, or how you will write MFD date, or what you write manufacturing complete date. We never ask. Even after, if there is a confusion among the inspectors, among the officers, what we will do, we can issue an advisory, we can issue a guideline, or if there is any need to harmonize, you're most welcome. We are always open to harmonize, so that industry as well as consumer should be at the win-win situation. Both should say yes, our concerns are being heard, and a solution has been given. This is the only purpose, and we are always with you, sir.
May I move to next question, Rajivji, or you want to ask something?
Please go ahead.
Okay. So another important and very interesting question is, somebody has asked, can we print different MRP for different states in India?
Sir, actually, as far as law is concerned, it's basically, if you will allow this, now it will open a new Pandora box. If we say that different states, let's say Delhi and Ghaziabad, Delhi and Gurgaon. So, it will create a problem that in Gurgaon, we are selling the same product at a different price, and in Delhi, we are selling it at a different price. So what we did, about in 2018, we have made the provision that there should not be two different MRPs. But again, if you have a better solution, kindly let us know. We are always open. We are always taking it to the forward, by which industry can grow, and consumer should not feel that I am being, cheated somewhere.
All right, sir. Thank you so much. There are many questions. I'm shifting one question to Dr. Asim Sahu. There are two questions actually, sir. One, which many people have put, is that that the state licensing authority is still asking a lot of questions between notified and non-notified devices. People have submitted application almost one and a half year ago, but they are not issuing license because it's not listed in the notified category of the product. That's one aspect. And the second aspect, one question is, if there is a manufacturing site located in Bangalore, and let's say I'm located in Mumbai, I want to apply for a loan license on this manufacturing site, which is located in Bangalore. Do I need to have an office in the state of Karnataka to apply for a manufacturing loan license, or I can do it from Mumbai itself? So these are two important questions where we seek an answer from you, sir.
Yeah, we'll try to clarify that, sir. Before that, the previous questions what you have raised regarding the acceptance of the symbols for the labeling, that provision we have made in the rules, and we are recognizing that BIS and the ISO, where the symbols they have certified, so that can be used in the on the label of the devices, and that can be accepted, provided that there should not be any compromise with the safety of the products. So that is the only some that concern is there, but we are recognizing that international symbols used for the applicable for the labels. Regarding your another that recent question what you have raised, first the categorization of the medical devices. So after that new your notifications, so many other medical devices that which are under now regulations, especially for the devices which pertains to the low risk, which is for which the license is issued by the state authority. So as and when it is brought to the notice of this office, we are issuing that clarification to the concerned state authority. Okay, because also it's a, we know ki it's a gray area. Just now we are now starting that ki these devices are under regulations. So the various different category also we are going to that identify and publishing on the website. By that time, individual cases based case to case, we are issuing that matter to the taken up that matter with the state authority concerned, and we are clarifying. Also, we are preparing the list for such category so as to publish on the website to have the more clarity on the that licensing part. So that clarification also that we are doing, and also the we are going to publish the another that category of the various medical devices which is not yet included in the existing list. Regarding your second question, where you are raised the concern for the loan license, if the firm is situating in the another state and they are applying for the license to the different states, whether they should have the local office in that state or not. It is not like that, sir. But yeah, that's certain state have raised that concern, and we have clarified them also. It is not like that, and whatever the necessary clarification, if we receive the from the applicant or the manufacturer center, we are issuing that clarification to the manufacturer also. And if it is from the state authority, we are issuing that clarification to the state authority also.
Right, sir. Sir, can like since these 2 points have come up, can there be public notification or public declaration or some sort of a letter being published from
So
in general, so that these questions and issues reduce, sir?
Will that publish that on the website to have the more clarity on the issues.
Right, sir. So there's another important question which concerns with the Department of Consumer Affairs and CDSCO. Somebody, in fact, there are many questions where there are smartwatches which has the measurement of SpO2. Okay. Now, the question is typically it should be claimed as a medical device because it's talking about SpO2. So in this case, how does what is the opinion of the CDSCO and what is the opinion of Department of Consumer Affairs as far as the compliance is needed? So maybe I'll go to Ashutosh first for his comments and come back to Asim sir.
Sir, if an equipment which is used for measurement it is covered under the legal metrology.
Okay, that's fine. Sir.
So how to get it tested, how to get it verified, it's a different issue. Certainly we have to do that. But if we are talking about the package commodity, so all the products are under package commodity. They are covered, whether it is a smartwatch or a normal watch, they are covered under the legal metrology package commodities. So declaration is one part, and the accuracy of the measurement is the second part. If it is used for a measurement, certainly its accuracy needs to be ensured.
Thank you. Maybe Asim sir can also comment on it because.
Sir, in this particular cases, generally, if the claim of that variables is for the therapeutic, like they are claiming it is for that SP2, SPO2, whatever that parameter they can identify, then we are regulating that under the Medical Device Rule 2017. But if it is for the wellness purpose, no any that though they evaluate that whatever the different parameter of the body, but they are not, it is for the general purpose. They are not claiming for any that therapeutic purpose, so that we are not controlling that under the medical.
Very clear, sir. Very clear, sir. So I come back with a more generic question many people have asked is, so first it goes to Ashutoshi again. Is there any medical device exempted from the legal metrology rules?
Sir, basically there is no exemption to any of the product or the sector or something from the legal metrology, because these rules are basically for the interest of consumer. And suppose we start exempting, then there will be a very there will be a very big question why we are exempting and why we are not exempting. So exemption is not a good thing. What we can do, we can harmonize, we can find the possible ways if there are some issues, there are some problems to sort out the issue. That is my request.
Right, sir.
I'll come in over here.
Yes, sir.
For legal metrology for packaging rules, the exemptions normally are typical when you are giving the product which is not going for retail sale many times. So what is a retail sale also has to be understood properly. So if you're supplying the goods, for example, for a government supply against a government tender, or to a hospital or a government hospital, which will not be resold to a consumer, then in that case, there'll be an exemption of complying with the requirements of the MRP. The rest of the requirements will still remain. Only the requirements of MRP may be exempted in such particular cases over there. But where you're selling to a hospital, and that hospital will be billing to a consumer or a patient, in that case, you cannot take the plea that I'm supplying to a hospital. It's an institution, it's not a retail counter, it's not a pharmacy sale. So I don't have to put the MRP. I seek exemption. If that hospital is going to be using your product and billing it to the patient, then MRP is required on the label. So that exemption does not hold good in that particular case over there.
Very important point.
Another area is regarding the question I have noticed over here also regarding capital goods or consumer goods like watches and stuff like that, or wearables and stuff like that. Now, these are all consumer goods. What may be a capital good for somebody may be a consumer good for somebody else. So it's not that if something is being sold as a ultrasound machine or an analyzer, as a patient, you may not be buying it, but the doctor is the buyer, he is the consumer then. So whether you are buying a thermometer or you're buying a BP instrument as a consumer, or the doctor is buying something for his clinic as a consumer from Amazon or whatever, or a distributor or dealer, he also needs to be protected, and he also needs to have the MRP clearly labeled on that. So one cannot just state that because I'm giving to an institution, that exemption will apply to me. And this was clarified, I think, in 2016 or 2017 by the department on that, and we've circulated to our members. But since the question was being again raised over here today, I'm putting it across over here. So like television also, when you go to Chroma, you buy televisions, there are different MRPs for different models. One cannot state that I've got 50 models and I cannot give 50 MRPs. Well, you have to be transparent to the consumer. If you have a variation, you've got an accessory, and that accessory or software is going to be making an impact. Even for every accessory, every software variation, you have to give that MRP change or price change. Otherwise, people will start misleading.
Yeah, that's right. So thank you. I would like to now thank everyone because we have already touched 6 p.m. And I would like to say thanks to all the speakers who have enlightened with their information and all the questions which have been raised by a very attentive audience. There have been a lot of questions, repetitive questions. We hope that many of those have been answered. So once again, I thank you all for being here and sharing your knowledge, information with people and the people who have attended to make it very, very productive. Many people are writing in their comment section that this session has been very, very good for them from various aspects. And once again, I also thank you, CCC and AMET, to create this platform for continuous education to the industry segment. Thank you very much and have a good day. Have a good evening.
Yes. Before we close, I would request if Mr. Sahu and I think Mr. Agarwal already has given the presentation, but if Mr. Sahu also can kindly share his presentation, we would like to circulate the presentations to the members. So those who are taking notes may ensure the accuracy of the information they're collecting, number one. And number two, people who missed out on the seminar, they maybe also have chance to educate themselves through the presentations.
Sure, sir, we'll share that presentation to the. Thank you.
Thank you so much.
Thank you. Thank you so much.
Thank you. Thank you very much.
Thank you, everyone.
Thank you.
Thank you, Simiji. You've raised very pertinent points and we have to satisfy your needs.
Yeah,
Thank you.
okay. Thank you.
Thank you.
Thank you. Thank you so much.
Yeah,
Thank you, Ramani, for
Ramaji.
organizing this.
Thank you very much.
yeah.
Thank you.